Valerie Powers, and today in this segment I want to speak to the special needs population on the specific topic of what we call special needs trusts. A special needs trust is an important mechanism that you add to your estate plan, and when I say estate plan, that's your will, perhaps another trust, your durable power of attorney, and healthcare directive. There is also a separate type of special needs trust where one may have a disability as a result of something surrounding their birth or a personal injury, in which case there may have been a lawsuit surrounding that. That is a separate type of special needs trust that we will talk in a different segment, but often referred to as a first party or Medicaid payback trust. Today's topic is the third party trust. The special needs trust that I'm talking about is one that you have as part of your estate plan, and the way that you are able to leave money to your child with special needs by way of an inheritance without making them ineligible for means-tested programs. Means-tested programs include programs such as SSI from the Social Security Administration and Medicaid or Medi-Cal in California, medical assistance in Pennsylvania, Medicaid in New York and New Jersey. Those programs look at one's assets and income. And income is an amount of money that comes in the month, and any amount that is accumulated is a resource. So it's very important for a child or an adult with special needs who will need to qualify for SSI or Medicaid and maintain eligibility for these services for their lifelong needs to never have more than $2,000, plus or minus depending on the program that they're receiving their medical benefits under. Similarly, if the SSI amount per month is important for them to receive. So what happens is your estate then pours into, think of your special needs trust as a cup waiting for your estate to pour into it. It stays in there. You name your child with special needs as the beneficiary for life, and you appoint a trustee. That person is in charge of setting up the trust with the bank account, receiving the money from your estate, and then managing that money for the lifelong needs of the beneficiary, your family member, or your child with special needs. That money is not considered to be a countable resource for means-tested programs such as Social Security and Medicaid, so the state and federal government, Social Security Administration, do not count it. And so it really creates a situation where you have the best of both worlds. They are qualified for benefits while at the same time have excess resources that are not countable in the special needs trust that can enhance the quality of their needs and also meet unmet needs that the Medicaid or Social Security or other disability-based programs cannot pay. So it's really important when you're planning your estate to make sure that you do not leave money directly to your child or family member with special needs, but instead leave it to a special needs trust.